plaintiff's lawyer on the other end of the spectrum seeks to show how the doctor violated the accepted standard of care. Now let us escape this, because we have other more important points. Types of liability. In law, we have three main types of liability. Number one, civil liability. As I have already said, civil liability results in paying damages or paying money to compensate for the harm that has been caused to the patient. And then we come to criminal liability. Criminal liability means that the error that was committed also affects the society or the public policy. That is why the wrongdoer or the doctor who committed this error, this kind of error, should be punishable because he breached the public policy. Therefore, the capital punishment is either fine, which in the final analysis means also money, but not paid to the patient, but rather the money is paid to the state. And then imprisonment. And then we come to disciplinary liability. Being a doctor in a public hospital or even in a private hospital means that you have an employer. So if you fail to do your duties as an employee, it means that the employer has the right to punish you. Third, besides the liability, the three types of liability, we can also have two more liabilities. But before we move to the other liability, which are simply liability in health regulations, if a doctor is not complying with the health regulations in a country, in a state, it means that he may be subject to also some sort of penalties. We call them sometimes administrative penalties and sometimes disciplinary penalties. For example, his license to practice may be revoked. Another example, maybe the health entity itself may be closed for a temporary period or permanently. Personal liability is also differentiated from vicarious liability. Here we come to a very important point for the doctor. What happens if the nurse, for example, commits an error while she assists the doctor in an operation room? Do you think that the doctor has to be punished or only the nurse has to be punished? And why? Can you tell me, gentlemen? Do you think that when a nurse, for example, in an operation theater commits a mistake and the doctor doesn't notice her mistake, maybe she is a nurse, maybe she is a technician assisting the doctor, one of the doctor's assistants. Do you think that the doctor will be responsible for his assistant's acts or omissions? Yes.
In the operation theater, yes.
Do I make myself clear for you? السؤال بالعربي، لو أحد المساعدين in Arabic، لو أحد المساعدين للطبيب غلط وهو يجري عملية جراحية داخل غرفة الجراحة، غرفة العمليات، هل الدكتور يسأل عن هذا الخطأ أم لا يسأل؟ Only the nurse. What do you think? Only the nurse.
If she is working under supervision of doctor,
Yes.
then doctor is also liable. If she is
Doctor is also liable and the nurse is liable.
Nurse is also liable.
Doctor
Do you
is
agree with this?
responsible.
Yes.
Doctor, whatever is happening is under the nose of the doctor.
Doctor.
He is the operating doctor.
Oh, you should
He
be
has to look into everything. If the nurse gives him
So
something
he is to blame also.
then he is
Both of
the
them.
main blame. Is the doctor.
Let us listen to Mr. Stephen.
I was just going to say there's a third party that's also liable, and that's the employer of the doctor and the nurse.
Yes.
The doctrine of vicarious liability comes from the Civil Code, and it says that if a person controls another person, and one of the instances it gives is like an employer and an employee, that degree of control imposes that vicarious liability. It doesn't replace liability, it's just an additional layer of liability.
Thank you. Let me put it simply. In law, there is a kind of liability imposed in case we have employer-employee relationship. Actually, in history, this kind of relationship is called master-servant relationship, or was called, had been called, but now it's called employer-employee relationship. If someone is doing something under full control and the supervision of another one, so the supervisor, the one who supervises his action, or is assumed to supervise, or has a duty to supervise the second one's actions and guide him and control his action, is also liable in law. So let us take an example from law. If a shop owner employs an employee or a worker in his shop, and the worker commits errors or commits an action that is supposedly should be supervised and controlled by his employer. In this case, what we call in law vicarious liability arises, which simply means the employer can be held accountable for the employee's actions. So, yes, Mr. Stephen.
Just to make it clear, I know it's implicit in what you said.
Yes.
Obviously that's an employee's act during the course of the employment.
Yes.
For example, if it's his weekend off and he's doing something, then the employer wouldn't be held liable. So it's acts during the course of the employment.
So, the vocal element here, the very important element, is whether the assistants are working under full control and supervision of the doctor or not. Or, let us put it in another way, the vocal point, the important point, the significant point, is whether the assistant, okay, is helping the doctor in the course of performing his profession, not outside the course of his profession, and commits an error. The doctor is presumably should have noticed this error and should have prevented it. The same thing applies to the tools and the instruments the doctor uses. If a tool or an instrument is, for example, malfunctioning, has a certain failure, and this failure can cause damage or harm to the patient. In this case, also the doctor is taken accountable for this damage, even he is not responsible for the instrument or the tool itself. So let us see this in detail later.
Yeah, I just want to comment.
Yes.
When you said about the nurse in the theater,
Yes.
doctor, for example, about the tool or instrument, he has got a responsibility. But if the nurse in the theater told the doctor the count is correct,
Yes.
she is also liable, because if she told me the count is correct and I'm close and there is a swab inside, then she has to share that. But suppose the doctor is working and with an assistant, a junior doctor, So the most responsible, the senior doctor, is responsible of the act of the junior doctor because he is under direct supervision. So if I got my trainee or resident doing a surgery, and there is a complication in the surgery, or there is any fault, it is not her fault or his fault, it is mine. So maybe I am assisting, or I'm just around in the theater, but it is mine.
Even if it is completely 100% the fault of the nurse. As we said, the nurse is working under full supervision and the guidance and the control of the doctor. So the doctor is also to blame. I know, I'm not a doctor, but as far as I know, some doctors have good practices. They ask the nurse to count and then to recount.
Yes.
Other doctors, yes. Other doctors, yes.
But in spite of that, if something happens, what can the doctor do? The
No,
doctor
they
can't
count.
start counting. She
Yes.
asks twice.
Yes.
Like,
Yes.
counts correct before
Yes.
final
She
close
counts,
also.
and let's check with her.
Unfortunately, in this case, the law punishes the doctor. Doctor has responsibility. Let us differentiate between the case of an assistant and the case who is under full control of the doctor, and the case of someone who is working independently, who is not working under full control or supervision of another one. Let us take this example. Suppose a doctor in a private hospital, okay, is engaged in a very technical or special operation. Now the doctor, that specialist, is responsible for his acts. There is no control or guidance or supervision of the doctor. In this case, if the doctor commits an error, the hospital has no responsibility at all. But let us assume that one of the instruments in the hospital is malfunctioning. In this case, the hospital itself, not only the doctor, the hospital itself can be held accountable for such malfunctioning.
I have a point. You told that if a person who is doing the surgery, if he is not privileged, the management is directly responsible. The
Yes.
management has to make sure that he is properly qualified, his logs are, proper log is there before he is given permission.
Sure.
So that's
But
number one.
this is another topic.
Number
This
two,
is another point.
Number two, I have a point with that, talking about the equipment. Just take an example of a diathermy or a pottery in theatre. It is a perfectly working, this thing has been checked and when everything is done. So before the surgery, before the time, everything is checked properly. During the process of surgery, it malfunctions and delivers a high voltage and there is a burn. So doctor is still liable or the management is liable?
In a surgical operation, I don't know what you call it, maybe respiratory system or machine, or the respiratory, the machine which gives
The ventilator.
yes, had a failure and didn't work, and the patient died. The court held that the doctor is accountable because he should have noticed
And this is
that
But you
the
can-
machine is working or not.
Every equipment, when it is used, it gives warning signals. Now, especially when you touch the ventilator,
Yes.
you can see the saturation.
Yeah.
You can see the saturation dropping,
Yes.
and then your vital signs will also be, there will be a lot of change in vital signs. This is about the ventilator. But regarding the diathermy issue, which another gentleman raised here, diathermy is usually checked before operation, but also if there is a burn, for example, if there is a burn, that's a direct liability for us as professionals. But if an equipment malfunctions while the procedure is being done, for example, somebody is doing a laparoscopic surgery, and suddenly there is a power failure, and UPS doesn't pick up, the automatic replacement, and there's a completely blind field inside. Now here, the surgeon will have not a direct liability, an indirect liability. Indirect and direct liability.
Sure.
Because it is not under his control.
You're right.
Power failure happened, it is not under his control. So every case has to be judged according to the circumstances.
Thank you, Dr. Fawu. As Dr. Fawu said,
Circumstances.
let us take the important point. As Dr. Fawu said, it is a question of control. Whether this falls under the control of the doctor or not. If it is under the control of the doctor, he will be blamed for neglecting to observe that malfunction. If it is not under his control or under his knowledge or can be noticed even by a reasonable man, the court definitely will not hold the doctor to blame.
Just a further comment. Just a further comment. I think if the hospital is joined as a defendant, and it certainly is the hospital's obligation to maintain its equipment properly.
Sure.
And as a matter of defence, I've done this myself, we would look at the maintenance and produce maintenance records to make sure that the equipment is serviceable and has been properly maintained in accordance with the manufacturer's recommended service schedule. So demonstrating that reasonable steps have been taken to maintain and that it is serviceable and that this is an inherent problem with the equipment itself rather than a maintenance problem which would be the responsibility of the hospital.
Yes. Thank you, Mr. Steve. Now let us move swiftly to another point, because I know that you will not stay after 2 o'clock. So let us say all this. We have more important points. Anything, anyway, is in the workshop material. But let us move directly to the 10 major questions on medical liability. Bad news, you have an arsenal of laws against you. Arsenal, which means many laws will hold you accountable. Number one, in Dubai, the medical liability laws or regulations include the following. Federal Penal Code of 1978. Federal Act relating to license to practice medicine, 1975. Federal Medical Liability, 28. Federal Act 2015 relating to private health entities. Dubai Government's Executive Decision 2012. So you have many laws, many regulations that you have to take in account. 10 questions which are very important in medical liability from the law perspective. Question number 1. Failure to treat a patient in emergency situation. According to the law, this is considered an error. A doctor may not abstain from treating a patient in emergency situations. Can a doctor refuse to treat a specific patient? The basic rule in law, as far as work contracts are concerned, is that that a person can refuse to do certain work for certain person. This is the general rule in law. The question now, can a doctor refuse to treat a specific patient? Can he say, no, I will not treat this patient?
It depends on the scope of
Unless it's an emergency.
Okay. Please. Is the question clear?
Yes.
No, if I can't do it,
Yes. What's your opinion? Can a doctor refuse to treat a specific person? No. No. What kind of liability a doctor will face if he refuses to treat a specific person.
If it's an emergency situation,
Yes, not in emergency situation only, but in any case.
to refuse an emergency situation, that would lead to a criminal liability. That is what, from my understanding. But if the condition of the patient is not critical, and then if he refrains from treating that patient, and there are no consequences, no major condition to that patient that as a result of not treating him, then the doctor would not be held liable. But he may have liability towards the hospital or the provider that he works for as an employee-employer relation.
Thank you. Do you think that there might be cases? Look at the drafting of my question, please. No. Look at the drafting of my question. Can there be some situations where a doctor can refuse to treat the doctor?
Yeah.
And in such cases, what should the doctor do?
Yes, I think there is some cases that the doctor can refuse to treat a certain patient. Of course, to exclude if there is an emergency or critical situation. But if, for example, there is questioning from the patient himself regarding the physician, whether he is qualified to do a certain surgery, or this relationship between the doctor and the patient, for example, is already under question. So I think doctor, the correct way is to refer him or to give the advice and to decline continuing the treatment of this patient.
Thank you. Good answer, actually. Here, what should the doctor do if the patient's case is not within the doctor's area of specialty? I think you answered, he can refer the case. Yes. Another question, or if the necessary facilities for treatment are not available, also reference. Thank you. Question number 2. Doctor's duty.
I have a question.
Yes.
If doctor has been treating a patient and the patient has raised a complaint against the doctor, still comes back for follow-up, does the doctor has the right to refuse to see him?
Again, please, the question.
Okay. Patient is being treated by a ex-doctor, and the patient has gone to the regulatory bodies and has put a complaint against the doctor. Again, he comes after a week or
Did the
so.
doctor refuse to treat him?
Can a doctor refuse to treat?
Why? What is the reason?
I'm asking you, can he refuse? Because he has already complained against him.
He has gone against me. He has gone to the regulatory authority complaining against me.
Yes.
That whatever the treatment I have done is not correct or something like that. Again he comes back to me. Don't I have the right to refuse to treat him?
Okay, I'll answer this.
Actually, it's not always the patient's right. There are doctors' rights also.
Yes,
It's not
sure.
that patients what they want, they
Sure.
can have whatever.
Now,
It's not like that.
reading the law correctly, says that a doctor in certain cases can refuse to treat the patient. Number one, the article which punishes or which prohibits on doctors not to treat the patient talks about urgency situations, which means that in other situations a doctor can refuse. So, of course, in the law, we have to read sometimes what is written on the lines, and sometimes what is written between lines. The law does not say this expressly, but by way of implication. So, in my point of view, I agree with you that according to the law, a doctor can refuse to treat a patient. Only exceptions should be clear. Number one, if the patient is in emergency situation, which simply means that if you refuse to treat him, he will die, or he is likely to have consequences, dangerous consequences, you are under duty to treat the patient. Number two, also there are exceptions mentioned in the law. Let us move to the examination and the diagnosis phases. Is the doctor under a duty to conduct all related examinations and the tests? In other words, this duty is absolute, or can exclude some tests? In this way, the duty will be relative. I'll say the question again. In or at the diagnosis phase and the examination phase, will the doctor be under duty to conduct all tests and all examinations, or he may exclude some tests and some examinations? I need an answer. Okay, but let us take the participation of everyone. Dr. Ala, please. Okay, after you, please. Okay.
Whatever the relevant test, depending upon the complaints and the diagnosis doctor makes on examination, whatever the relevant test required for that situation to that patient have to be done.
Okay, thank you. Give the floor
this
to
one
Dr.
depends
Ala.
according to the case itself.
Yes.
Just only, I agree about that.
Okay.
Depends upon the case.
Here is the answer. There are situations where a doctor needs not to conduct all tests. For example, if the tests are still at the experimentation phase, or likely the tests themselves are likely to harm the patient, or there is controversy about the use of these tests and their potential risks, or even if the patient gives the doctor incorrect information. For example, the patient didn't say what he suffers from correctly to the doctor. In this case, if the doctor neglected a test, it will not be a medical error, because the blame here falls on the patient.
There's the difference between neglecting the test or omitted the test.
Yes.
He didn't want to do it because there's something wrong.
Yes, he didn't do the test because simply it was not necessary for the case. Let us move to question number 3. Use of unlicensed or illegal methods in treatment. I read this sentence in Act 28, and actually I couldn't understand. Although my area of specialty is drafting, even at the international arena. The law says that a doctor may not use unlicensed or illegal methods in treatment. Number 1, what do we mean by methods here? According to the regulation, it means also, besides instruments, equipment, medication, medicine, and any way of treatment. So the scope is very wide. But once again, what is the difference between illegal and unlicensed? What does the word methods mean? And what is the difference between unlicensed and illegal methods? Actually, I don't understand it, because simply unlicensed methods are illegal. They cannot be legal. And also illegal means unlicensed. So I think that these words should be clearly defined in law or in the regulations. Question number 4. Duty to inform the patient about the nature of his or her illness. According to Article 4, Paragraph 4 of Act 28, there is a mistake in writing the year, a doctor has a duty to inform the patient about the nature and the dangerous impact of the patient's illness, except in 2 cases. This is the drafting of the law. If this is against his interest, number 2, depending on his psychological state. Now let us read this again. According